Lana Reed, Assistant Public Defender, with and on behalf of Mr. Hunter. Can you state your name for the record?
Reginald Hunter.
This one starts out looking like just another quick probation check-in. But listen closely, because these are the kinds of hearings where people accidentally talk themselves into jail time. We've got Judge Simpson on the bench, we've got probation laying out a list of non-compliance issues, and we've got a defendant, Reginald Hunter, who's already had chances and still didn't lock in the basics. And when probation says non-compliant with all the terms, that's not a vibe statement. That's code for, we've tried the soft approach, now we're asking the court to enforce consequences. The big theme in this first part? Money, reporting, and accountability. They're going to talk about a balance owed, community service hours, and the simplest requirement of probation: show up, report, and follow instructions. But the twist is always the human part. Jobs, kids, real life. The court has to weigh structure versus sympathy. And the judge is going to make it very clear that I feel bad for your situation does not automatically cancel out you ignored the terms. So as we go in, pay attention to the language. When probation says failed to, and when defense says he's trying, Judge Simpson is going to choose which story matches the paperwork. And that decision can flip the whole day from warning to cuffs.
Teresa Clare on behalf of probation. Your Honor, Mr. Hunter is before the court for a violation of probation hearing. That hearing was adjourned by the court from August 9th. Since that time, Your Honor, Mr. Hunter remains non-compliant with all the terms. He owes a balance of $555. His last payment to the court was March 7th of this year. He's failed to complete the behavior modification class. He failed to complete 25 hours of community service, failed to report to probation as directed, including failing to return a signed copy of his probation order. Given the violations, probation asking that Mr. Hunter be remanded to serve 5 days in jail for violations to date. That the court at this time extend his prosecutor deferred sentence for a period of 4 months, that he pay $155 by the end of the month on August 31st, then $100 per month, that he report to probation on Monday, August 28th at 11:30 a.m. in person, then as directed by probation, and for him to become compliant with all terms that was previously ordered by this court within 30 days, and reschedule his currently scheduled review hearing date for September 13th to January 10th, 2024.
Your Honor, we did review this information and I did inform Mr. Hunter of the recommendation. He is asking if the court could be lenient at all. He was previously incarcerated for a period of 5 days and he lost his job during that time. He has had to find a new job, and if he has to turn himself into custody, he will lose that job as well and be unable to make payments towards his balance. Additionally, he is the sole caretaker for his 5-year-old child, and he does not have any alternative means for care for her. He did send me some documentation that he has been volunteering at Growing Hope. I don't have confirmation of the number of hours, but he has been doing that. He is compliant in another case that he has going on as well. And so he's hoping that the court would have a little bit of leniency with him in this matter so that he can get back in compliance without.
This is the defense playbook, and it's not just excuses, it's mitigation. They're basically saying, Judge, the punishment you're about to give will break the very thing you want him to stabilize. Job loss, childcare, and the domino effect, those are real. And from a courtroom strategy standpoint, the defense is trying to shift this from he's refusing to he's struggling. But here's the problem. None of this directly answers the court's biggest question. Why didn't he report? You can be broke and still show up to probation. You can be overwhelmed and still turn in the signed order. Courts get sympathetic to hardship, but they get allergic to silence and avoidance. Also, pay attention to the volunteering claim. Volunteering is good, but probation is talking about specific community service requirements with verifiable hours and reporting. I've been volunteering sometimes doesn't match what the court ordered, and judges don't like when someone tries to swap terms on their own, like, I did a different version of compliance. Engagement question. Do you think the court should treat job plus child caretaker as a reason to avoid jail entirely because stability matters? Or do you think that's exactly why compliance matters even more, because the stakes are higher?
Getting further off track by having to be remanded to custody.
And Your Honor, I guess probation's stance with that is Mr. Hunter had an opportunity since August 9th, find his way to my office to get into some sort of compliance. And he did not do that. And it's my understanding that the 5 days jail that he served was for being non-compliant with this other probation that he's telling me he's compliant.
You want to say, young man? Sorry. I'm going to extend the prosecutor's deferred sentence for a period of 4 months. You are to pay $155 by August 31st, 2023, then $100 per month. I'll order that you report to probation on August 26th. I'm sorry. 28th. I'm sorry, August 28th. I'm sorry, 2023 at 11:30 in person, then in report as directed. You're to become compliant with all previously ordered terms. You're to do that within the next 30 days. I will reschedule your current September 13th review hearing to January 10th, 2024 at 9 a.m.
This right here is the judge laying down a roadmap. Very specific, very measurable. And that's important because in probation hearings, ambiguity is the enemy. Judge Simpson is setting concrete deadlines. Pay this amount by this date, then pay monthly, show up in person at a specific time, then follow directions, fix compliance within 30 days, and come back for review. This is the court saying, I'm giving you a structure to succeed, and you're not going to tell me later you didn't know what to do. Legal clarity. A deferred sentence extension is essentially the court keeping the sentencing consequences hanging while giving you time to prove you can comply. It's not a free pass, it's leverage. The court is saying, you can stay out and fix this, but if you don't, you're going to feel the weight of the sentence. And the payment plan is also a fairness move. They're not demanding the full balance immediately. They're demanding consistent progress.
I am, when I review the file, you were given numerous opportunities to try to get this right, and you haven't done it. Incredibly, I'm going to remand you to the Washtenaw County Jail. You're to serve 5 days for your violations today. Defendant is remanded. Officers. Court calls the case of the people versus DeAndre Bonner.
Notice how fast the court pivots. One man just got remanded. No dramatic pause. No emotional buffer. The machine keeps moving. That's probation court in its rawest form. One life altered, then immediately on to the next. And now we meet DeAndre Bonner. Different name, different case, same underlying theme. Probation is not a suggestion. What's powerful here is the contrast you're about to see. Hunter had some payments, some volunteering, some narrative of effort. Bonner, we're about to hear a story that's heavier. Custody, 0 payments, incomplete programs, and even a brand new domestic violence case hanging in the background. This is where probation hearings start to feel like a warning reel. This is what happens when problems compound instead of resolve. As viewers, this is where you should ask yourself, is probation meant to be a ladder out of trouble, or a trap door that keeps opening under people who can't keep pace? Because the court sees patterns, not intentions. And Bonner is about to walk into a courtroom where patience has already been used up on someone else moments earlier.
Good morning, Your Honor. Assistant Public Defender Lauren Perny on behalf of Mr. Bonner. Can you state your name for the record?
Yep, Darianne Bonner.
Bruce Clare on behalf of probation. Your Honor, Mr. Bonner is scheduled before the court for a violation of probation that was adjourned from August 9th. Mr. Bonner was in custody the last time that you saw him on August 9th. Mr. Bonner is still non-compliant with the terms that was ordered by the court. However, I will indicate to the court that he was in contact with me yesterday to discuss some of his non-compliance. He has failed to return his signed probation order. He failed to report to probation after December of 22. He has a balance of $1,775. He's made no payments to the court. He's failed to provide proof of treatment. However, he was attending the recovery groups, however, did not finish that. Just stopped going towards the end. He failed to provide proof of his AA meeting attendance. He did indicate to me that he did do those, however, did not turn in proof of those. He was advised to bring those to court today. He's failed to provide proof of his victim's impact panel attendance. He indicated he did that as well, however, I don't have verification. He's failed to report to probation as directed. He does have the new criminal case, which we saw him on yesterday, domestic violence with an alleged date of offense of July 5th. He has a final settlement conference in that case on October 13th. In that case, in that police report, there is reference to him drinking alcohol, where he admitted to the officer that he had a lot to drink the day before. And I have provided that to the court so that the court does that. Given all of the violations and the status for Mr. Bonner being in custody, probation is recommending the 24 days in jail with credit for 24 days that he has served today, that he continue his probation term, that he make a payment of $175 by August 31st, then $160 per month, that he report to probation today, directly after this hearing, to get compliant with the main parts of signing the order and getting all of his referrals, then as directed by probation, that he report over to Community Corrections today to re-enroll in the CCOP program and restart that.
This report is heavier than the last one in every way. First, the balance is higher, $1,775, and unlike Hunter, Bonner has made 0 payments. Second, he didn't just miss a check-in, he stopped reporting entirely after December. Third, he started programs and quit. That matters because courts view unfinished treatment as a warning sign. It suggests avoidance, not just delay. And then comes the real gravity, a new domestic violence case with an alleged alcohol admission. That changes everything. Probation isn't just about paperwork anymore, it's about public safety. When a probationer picks up a new charge, especially something violent, judges stop thinking in terms of help him stabilize and start thinking prevent escalation. Legal clarity. 24 days in jail with credit for 24 days served means the court is formally imposing a sanction equal to time he's already spent in custody. So technically, he won't serve new days today, but it's still a conviction of violation. It resets the authority of the court and reaffirms that probation continues under stricter eyes. Engagement question: do you think the court is being merciful by crediting time already served? Or is this just a symbolic punishment that risks letting someone slide despite deeper issues like alcohol use and violence?
And then become compliant with all other previously ordered terms by this court within 30 days.
Thank you, Your Honor. I did have a couple lengthy conversations with Mr. Bonner yesterday. What Ms. Polera stated, he was in touch with her. He states to me he did attend AA meeting, victim impact panel, but again, he does need to get that information over to her. He stated he brought it with him today. He did, while he was in custody, did lose his job. He did lose his apartment. So he's trying to get back on his feet after being released. He's currently looking for a new job. I did speak with Ms. Polera this morning about an ability to pay for him as well. And she's going to get me a copy so I can discuss it with him. But the plan is for him to report to probation after today, turn in that the proof that he does have, and possibly discuss that ability to pay for him to see if we can get the payments reduced or something that he can handle and manage at this time.
And man, anything you want to tell me?
Just that, I know I messed up, so just reaping what I sow. I apologize to the court, and that's pretty much it.
Give you a chance to get yourself on track and see if we can get this going, okay? So, since the defendant 24 days in jail, credit for the 24 that he has served for the violations to date, I'll continue your probation. You're paying $175 by the 31st of August 2023, then $160 per month thereafter. You are to report to probation today in person after the hearing, and then you're to report as directed. You understand that? report to community corrections today. You're to enroll in the CCOP program. You're to become compliant with all previously ordered terms within 30 days.
This ruling is deceptively calm. On paper, it sounds gentle. Credit for time served, probation continues, structured payments, immediate reporting. But make no mistake, this is the court tightening the leash. Judge Simpson is converting this from, "we hope you comply," into, "you are now on a countdown." Legal clarity. When a judge says, "report today," that's not symbolic. That means leave this courtroom and go directly to probation. Miss that step, and the next hearing becomes a warrant hearing. The CCOP enrollment order is also critical. It's a structured program often tied to substance use or behavioral change. This isn't about money anymore. It's about intervention. Emotionally, this is a crossroads moment. Bonner isn't being crushed. He's being He's being cornered into action. The court is saying you can still choose a path out of this. But if you don't move immediately, the system will move for you.
Right.
Thank you, Your Honor.
Thank you, Your Honor.
Brent Ingram on behalf of the defendant, Judge.
All right. I have this set for a discovery here. Where are we?
Yes, Judge, if you may recall last time, after our last appearance, I feel like I should stand.
No, it's either way.
After the last hearing, Your Honor ordered that, excuse me, this would be adjourned for a further discovery hearing. The plaintiff was to provide a list of outstanding discovery within 7 days. We did do that. Defendant was to respond to that within 10 days, which would have been last Tuesday. We did not receive the discovery last Tuesday. We did receive it on Friday at 4 p.m. So I had a chance yesterday during our one business day to review what was provided. There remain a number of incomplete responses. Your Honor had also ordered that Mr. Stuart Beal appear in person at today's hearing so that he could personally respond to any of the outstanding discovery, and you would contemplate the possibility of a deposition of Mr. Beal as well. Mr. Beal is not here today, as you can see, Judge, in contempt of this court's order. So in addition to the remaining discovery issues that we have, Mr. Beal's failure to appear today, despite the court's order, I think at this point, given the ongoing issues, would warrant some sort of sanction. We would be requesting that.
Your Honor, we did provide the discovery. We attempted to provide it as completely as we possibly could. It was not my understanding, and I apologize, that Mr. Beal was to be at this particular hearing. I can take responsibility for that myself. However, if Mr. Beal's presence would be beneficial, as I stated at the last hearing, I'm sure that we could arrange something in terms of that. A brief adjournment or resetting this. We could go over the discovery again. I do believe at this point, however, we have provided the most complete discovery that we can to opposing counsel. I don't see that there's really much else that we can do in terms of that. However, I do think it probably would be beneficial if Mr. Beal could appear, and if we could just reset this for a week or 2 weeks, I'm sure that we could arrange that.
What specifically is the incomplete responses?
So Judge, I think most of them are incomplete to some extent. And I'll just provide as an example. We asked, identify the name and contact information of any and all persons with knowledge of facts relevant to any claim in this lawsuit and state the matters about which they have knowledge. The answer was Chandler Kennedy, property manager, Richard McCauley, maintenance supervisor. Clearly, Stuart Beal at the very least belongs in that list. However, we think probably a number of additional people who participated in the maintenance work, both during Ms. Jackson's tenancy and subsequently, would be in that list. So just starting from there, there's really a sort of lackadaisical attempt to respond to the interrogatories, I believe. And again, I do not in any sense mean to cast aspersions on Mr. Ingram. This is I think a matter of how his client is responding to the discovery. As far as the most pertinent things that are missing, we had requested communicate any and all communications about maintenance issues during Ms. Jackson's tenancy. We were provided, I believe it was 8 maintenance requests and 1 email exchange. We know for a fact that there is far more than that. We know that Ms. Jackson, for example, complained about the mice on probably 5 to 10 occasions, and there's one of those in what we received. We don't have those communications ourselves because they were mostly requests that she made through the portal, and perhaps some additional ones that were by text or email, I'm not sure. But we know that that's incomplete because we know that she made those requests. And that's very pertinent to a couple of our claims here. In addition, we had asked for a detailed list of measures taken to eradicate mice, the dates and times that those measures had been taken. And the response to that was, tenant made no effort to keep apartment in clean manner in order to not attract mice. Field property sealed all possible entry points and provide traps as a courtesy. Then explained again, she needs to put effort into this issue as well. That's just non-responsive and incomplete. And again, this is one of the core issues, was the continuing mice infestation throughout her tenancy, despite her clear indication that she and several of her children have allergies to mice droppings and such, and we're experiencing adverse health effects. The response also states we had asked about the date on which she returned the keys to the apartment, June 30th. And we requested the sign-in log when she returned the keys to the management office. The response was key return form attached. Also, there is no sign-in log. Tenant also did not enter building, remained in her car. Now, when I read this myself, I thought, wow, that's some customer service. You can stay in your car and someone is going to come out to your car and take the keys from you. Of course, when I checked with Ms. Jackson, she said nothing of that sort occurred. So I have real concerns about the veracity of some of these responses. I don't know where that information came from. I don't know who would testify to her remaining in her car and not signing in. And again, this issue is pertinent to exactly what was removed from the apartment prior to her moving out, the exact time that she actually turned in the keys. And so these are some of the most salient issues, but again, pretty much every response, I'm not gonna say every response, but a majority of responses are in some way either non-responsive or incomplete, and really suggests to me that our discovery requests in this court's order are not being taken seriously. I've just mentioned one additional thing, which is we've requested reports and communications about any inspections performed. There were 2 letters from MISHDA provided about the termination of the HAP contract and some back and forth about that. We know for a fact that there were city inspections and those reports were not provided, and we believe there were other communications from and with MISHDA and those were not provided. We believe those to be in the possession of defendant, but at this point, I guess I would need to do a subpoena to those third parties to really complete our discovery.
Your Honor, if I may, we provided multiple attachments, I believe 19 in total. We provided folders with multiple photographs, 10 to 20 photographs in single folders. We labeled them. We provided all the reports that we had records of. Additionally, as far as some of these alleged requests, the only conclusion I can come to after my conversations with my client is that some of these were oral and there wasn't record kept, but I strongly object to the characterization that we're not taking this seriously. This is, I believe, the 3rd crack that we've had at this. We went out of our way to provide the best discovery responses that we could. I think at this point we're going in circles. If Your Honor would like, I have no problem getting Mr. Beal to appear at another hearing, and perhaps we can just clear up any ambiguities at that time. But in terms of the actual discovery provided, I think this is just nitpicking at this point. We've done the best that we could. This is one tenant among literally hundreds. There are not going to be just reams and reams of detailed evidence about every single transaction that ever occurred with one particular tenant. We did the best that we could. We're not trying to be contemptuous. It's not lackadaisical. It's the best job that we could. So again, I strongly object to that characterization. And again, if the court would please, we have no problem providing Mr. Field to clear up whatever remaining ambiguities there may be at this point.
Here's what I'm going to do. I'm going to adjourn the hearing to September 19th, 2023 at 9 a.m. I will issue a show cause hearing on that time also for defendant Beal. Is it Stewart that's appearing? Stewart? For Stewart Beal to appear at that hearing.
Understood.
As he was supposed to be here today.
And I apologize, Your Honor.
I'm also, and so that you can understand the clocks that's running, it's going to be $100 per day until discovery responses are cleared up and complete. I will make that determination on the 19th as to what is complete, what may be missing, and the like, and then come to a calculation as to how we're going to do that. Right? So the clock is running from today to get these things cleaned up.
Okay, so just to be clear, Your Honor, the sanctions would start after the 19th, but you are going to review what we provide in the interim?
No. They start today. I want them cleared up.
Okay.
If, let's say, everything gets cleared up on Friday, which would be what, how many days? 25th, so 3 days from today.
Your Honor,
Everything's cleared up by that time. But you come here on the 19th, I figure, by the 25th, you got it cleared up, it's 300.
Your Honor, if I may, again, like I said, I think that some of this is unreasonable. Could you at least give them a few days, as we did before, to provide some sort of, guidance as to what they think they still need, at least a day, any amount of time, so that I can give that to my client and say, look, the judge is going to sanction you, you need to get X, Y, Z, because what's been stated on the record to me, again, is not completely accurate, in my opinion, in terms of what could be provided. I think some of it is frankly speculative.
Judge, if I may respond.
Yes.
As Mr. Ingram indicated, this is our third go-around with discovery.
Oh, I know.
Our initial requests were sent in March. And again, the responses have been dilatory throughout. From what we have so far, we think there's a pretty clear MCPA violation, which comes with attorney's fees. We have expended an extraordinary amount of time and effort trying to get the discovery that we need in this case and to re-articulate for defendant repeatedly what is missing. At this point, I think our requests are very clear. I think the inadequacies are very clear. If I'm gonna have to send a further clarification on what we need, then I would ask for a sanction of attorney's fees in addition for the time spent on these matters.
I don't agree with that, Your Honor. When she's saying that this or that must exist without any proof, that's speculation. Because she says her client is saying that.
Listen, I get that.
Okay.
I understand all of that, folks. What I'm just indicating is that some of these, those are kind of iffy answers. I don't have him here. He's supposed to be here. And my ruling stands. It starts today.
Understood.
As to what the figure is, I'll figure the money out on the 19th. But you guys got to get this cleared up. I mean, if there are repairs that came through, then you make it clear that they weren't done through the portal, they were done through there, and therefore we don't have a record of anything along those lines. But what you get right now is not that.
Fair enough.
Okay, thank you, folks.
Thank you, Judge.
Anything else?
This is judicial escalation in real time. A show cause hearing is the court saying you will appear and explain why you should not be punished for ignoring me. And the 100 per day sanction is not symbolic. It's a financial pressure valve designed to force compliance. The judge is converting delay into cost. Every missing document now has a dollar value attached to it. Legal clarity. These are coercive sanctions. They're not punishment for the past. They're leverage for the present. The court is saying, you fix this, the bleeding stops. And notice how firm Judge Simpson becomes. They start today. No grace period, no buffer, because this is the third round. The court is done negotiating with inertia. What ties this entire video together, from Hunter to Bonner to this discovery fight, is authority versus delay. In every case, someone waited, someone didn't act, someone hoped time would soften consequences, and in every case, the court responded the same way: structure, deadlines, enforcement. Probation teaches one lesson: freedom requires participation. Civil procedure teaches another: fairness requires cooperation. When people ignore either, the system doesn't collapse, it hardens. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.